Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. This is our bi-weekly, once in 2 weeks, community conference call every other Thursday at 12:30. Phone number to call 202-800-8394, 202-800-8394. You would have heard the standard disclaimers when you log in. This is not an attorney-client relationship creation call, merely providing you whatever information we can, no guarantee or warranty attached to the accuracy of the information. Let's begin first of all with our frequently asked questions. There are certain questions that are asked quite often, so I tend to mark them as frequently asked questions. The first one is from Katharaju Pandurangappa. His professor has been denied a tourist visa a couple of times, once in 2012 and once in 2020. And he seems to have a good case because the first time around, he was just going for a conference. He had applied, this is in 2012, applied for a visa. He got rejected. They're saying he doesn't have sufficient funds or proof that he will come back. I don't think the funds is the issue. This is a 214B denial. Basically, everyone who applies for a tourist visa or a business visa, B1, or a student or a J1, they have to convince the consulate that they are not going to live in the United States permanently. So they have to establish their non-immigrant intent. This is a judgment call. It is extremely difficult to challenge a 214B denial. In 30 years of our practice, the only time I was able to successfully challenge a 214B was quite a few years ago, where a PhD student who had gotten a full scholarship into a PhD economics program into an Ivy League school in the United States was declined a student visa under 214B. She had been to the United States several times. So it appeared to me to be a classic case for an approval. So we wrote to the consulate and requested a supervisory review. And that student visa was approved, much to my own surprise. So your professor, Mr. Raju, can try approaching a lawyer and try writing to the consulate for a supervisory review, because today his situation is that he's got 4 family members, total of 4 people. He's got property, he's got employment letters, he's working as a senior manager HR. So it looks like he can have a supervisory review. I'm not saying that will work some miracle, but it's worth trying. It doesn't hurt. Another thing that has helped many people, and I've mentioned this in the past, if he has been to other countries and come back, that tends to be an indicator that he has no desire to settle into a third country. He is happy in India. *5 on your phone, please. Press *5 if you have a follow-up question. No new questions, just a follow-up question. Okay, let's go on to the next frequently asked question. This one is from Don Fast 2002. He's going for his interview, or she's going for her interview next month for naturalization. It was cancelled once. I took 3 trips outside the US and one last more than 6 months, but less than 1 year. I waited for more than 5 years since my last entrance. Very good. That's smart. Which is June 2013. Should I be worried about my interview since I broke the continuity? In your case, I'm not that worried about the continuity, because you waited more than 5 years since your last entrance. So there is no break in your presence in the United States for last 7 years or so, 2013. So therefore, I don't think the previous trip should be a major issue. But I do recommend that you discuss with a lawyer your visits abroad prior to 2013. Remember that government is going to question. They don't usually go beyond past 5 years for residence. But if they want to be nasty and uncomfortable with their approach to interview, they could go back and say, well, have you really abandoned your green card at some point? For which one of the indicators is that you were gone for more than 6 months. So you should have a lawyer look at it. It doesn't look like it's a serious major issue, but there's no sense in taking a chance with this government who's particularly hostile to immigration, whether it is legal immigration or illegal undocumented folks. So how should you defend yourself? Have a quick consult with a lawyer. Just make sure they look at your situation, overall picture. Why were you gone? Did you take up a job in your home country? Did you have any ties to USA, etc.? So that should be looked. The entire context of your case should be looked at just to make sure there are no obvious issues that are screaming at us. I don't think there are, but you never know. *5 if you have a follow-up question on this. No new questions, please. Follow up on this question. Okay, let's go on to the next. I combined actually three people's questions into one, because all of them are dealing with similar issues. What is the definition of an executive or a manager when we try to do an L1A or an EB1C based green card? It's an interesting problem. In fact, we are preparing a lawsuit, and hopefully that will be filed by next week, against the government for misdefining and misapplying the law. I'll explain the law to you guys. What is a manager or an executive? But remember, this is important because EB1C category is wonderful. Of all the categories, if you were, for example, born in India, if you are under EB2, you would have to wait, 12 years, 13, 15, 14 years. But under EB1C, that could be considerably less. There was a time when EB1C was current. Now it may be back to 1 to 3 years, but it's still much better than 14, 15, 16 years. So therefore, EB1C becomes very important. And how does it work in practice? We have several cases where employees of corporations that have a branch or a parent or a subsidiary, affiliate, etc., outside the USA approached us and said, look, I'm getting posted in Canada, or I'm getting posted in Japan, I'm getting posted in India. Is there any way I can come back on an L1A or an EB1C or both? And we are doing actually several cases like this. So what we do is we look at the job description that you are going to be taking up in the foreign country outside the US. And we try to assess whether under the current criteria, and of course criteria could change by that time, but under the current criteria, do you qualify as an executive or managerial employee, which is a precondition to both L1A, which is an immediate visa, allows you to come to USA without any problem with H1B quota, etc., and EB1C, which is employment-based green card for multinational executives and employees. So when you look at the job description, we have to look for two things. It can be a mixture of both these things, or it can be just one of them. You can be a professional people manager or a functional manager. So if you are managing a staff of 3, 4, 5, 10, 15 software developers or engineers, you should be considered to be a professional manager or executive because you are managing other professionals. But what if you are managing just people who are, for example, dock workers? So you've got a staff of 500 dock workers and you are their supervisor. That probably will not qualify as a people manager, because in order for you to qualify as a manager / executive, you must be managing other professionals. Okay. That's the people manager or professional people manager. Then there is a functional manager. A functional manager may not manage people, but they manage a separate function, a self-contained function of the corporation, which is important to the corporation. One example of that, and I've given that example before, we had a buyer of a company from the Middle East. The buyer used to sit at home and she bought millions of dollars worth of goods without stepping outside her room. All she needed was a fax machine, internet connection, and a telephone to do her work. She did not need a staff of 50 people. So the government denied their L1A. They came to us, we refiled and proved to the government that she had done so many millions worth of goods purchase based upon her own discretion, that there is no person who's less than an executive or managerial level employee could be allowed to make those kind of decisions. So this is an important function for the organization, acquiring goods that they are selling in the Middle East. It is a function in regard to which the employee is working at a fairly high level. She does not need permission from her company to buy stuff. She already has the permission. She has the discretion. So we were able to prove that she was a functional manager. We've had similar cases where, for example, there was somebody who was a pricing manager. They came into projects more than $5 million or more and decided what the services of the company would be projected or billed at. So this was for responding for requests for proposals, etc. So if you think about it, he doesn't have anybody that he's managing, but he is at such an important place that he is managing the pricing of high budget projects. Therefore, he's not really a people manager, but he's a function manager. So you can be a mixture of the two also. Sometimes you manage both people and functions. And by the way, the fact that you're managing employees outside USA could also count. So we had a case recently in which this is again a multinational, well-established company with offices in Canada, India, and USA. Government denied our case, saying that this is not a manager because some of the team that he was managing was located in Canada, and we proved to the government that they were wrong in their assessment and that even managing people outside the US counted as a part of the management responsibilities. This case was approved in appeal. Normally, I don't file appeal in these cases. I would rather take it to court. But sometimes some cases are easier to be processed in appeal. So this is an example of a functional as well as a people professional manager. So the first question was from Prasad PP. I am on H1B, I-140 is approved. And by the way, you can transfer the priority date of your old EB2 or EB3 case to your EB1 case, which gives you another huge boost. My employer is sending to Canadian branch to work for 2 years. Good. I have one person reporting offshore India. I am not designated as a manager. Upon return to the US after 2 years, does my application qualify for EB1C? It does not look like it as far as people manager is concerned. But if you are managing a function of the organization, that should be discussed with your lawyers, sir. Before you leave USA, have your lawyers bless your intended job description in Canada and then the intended job description when you come back into the United States. So let's just make sure both of them are covered under the multinational manager or executive employee. Okay. I can't really comment in vacuum without looking at the two job descriptions, but you don't appear to be a people manager. Normally having just one direct reportee may not be sufficient, but you never know. We have to look at the entire facts and circumstances surrounding the case. So the answer, maybe, maybe not, depends. Looks like you will not qualify, but you never know. Hold on to your questions until I finish the other two. So Vikas 18 said 1 year outside the US. I'm currently employed by a multinational corporation in USA on H-1B as a manager. Headquarters is in Europe. There are 15 plus contractors and a couple of full-time employees. Well, contractors count. There are actually rulings from the Administrative Appeals Office, and I think even in one of the adopted decisions, is a matter of G, one of the adopted decisions in which the government said, yeah, we'll count contractors also when we determine your role as a people manager. And I already said that the fact that they're outside USA doesn't matter. It could count. If I spend 1 year outside of USA, not continuously, say 5 months every year. Okay, now this is another interesting fact. You have to be outside USA for 1 year, 366 days, I would say, to come back under L1A or EB1C category. But can you break that continuity? So the answer is only for brief periods of time, and the time that you are here, you will have to spend extra outside. So let's say in my 366 days, overall, I visited USA for 45 days. I was inside USA 10 days at one time, 5 days another, 20 days another, 10 days another. So let's say the total comes out to 45. You will have to spend an extra 45 days outside USA. Okay. Second problem is, if you are spending too much time in the United States, and nobody knows what the definition of that too much time is, you could be asked to start the 1 year outside USA all over again. So you could reset the clock if you spend too much time in the United States. So you are saying, if I spend 1 year out of USA, not continuously, say 5 months every year, it doesn't count. It doesn't count. It will not work. Okay. And the last one was from Nirmal Kurup, whose case was a little different. And I think you're going to be okay, Nirmalji. You said, I'm on L1 visa since 2018, completing my 2 years in USA in May 2020, and trying to apply for a green card. Someone told me that I cannot apply for a green card if we cross 2 years in L1A, since we need to show 1 year out of the last 3. And the answer is, in general, that is true, but not for somebody like you. In your case, the counting begins from the date you entered the United States for the first time. So we'll go back 3 years from the date you entered USA the first time. Why? Because if you are working for the same group of companies, which comprise the group that is going to sponsor you for your L1A and or green card EB1C, then if you have already been working with them on H1B or L1B or L1A, we will discount that time and we will go back 3 years from the date you first entered the United States. So you should be fine. Okay. All right. So I covered these 3 sets of questions, all related to L1A and EB1C from 3 different people. If you have any follow-up question on this, what I have discussed, press *5. Press *5 on your phone. Okay. Moving along to the, there is one. There are 2 people who have questions. Okay. Let's see if we can get them both. One is from New York, and the other one is from North Carolina. I remind you folks, please, no new questions, only follow-up questions. Okay, New York, go ahead. I can hear you. New York. Area code 980. Go ahead. Or do I have the wrong? Is it Carolina? Yep.
Hi.
Go ahead.
Yeah, my area code is 980, North Carolina.
Okay.
So this is a follow-up question. This is Prasad. You talked about my case may or may not be qualified based on the report.
Because you're doing only right. You're supervising only one person, right?
Right.
Okay. Go ahead.
And does that person have to be in the same location? Is
No.
there any constraint for that?
No, there is no such requirement. So I have cases where the European branch of the company was managing their projects in Belarus and 2 other countries. So they had employees spread over all through the earlier known as USSR, that area. We didn't have any trouble, and it's by law we shouldn't have any trouble. Even though the managers are sitting in Europe, the people who are doing the work are in the former USSR. I don't see it as a problem. I've never had any issue with that. Okay.
Right. In my case, I would be locating in Canada, and the person that is reporting sits in India. And also regarding one more thing, does the designation matter to be qualified for EB1C?
It could. So let me begin by saying that it's the substance, not the form, that matters. It is what you do, not what you do as, that matters. So if your designation is project lead, but you're really a systems manager, we look at your job description. But there can be extreme circumstances. If you are called junior programmer, but you claim that you are a executive or a managerial level employee, that seems unlikely. Very unlikely, because nobody will be designated junior programmer if they were a manager or executive level employee.
Okay, so when we say somebody is reporting, does that mean that the person who he reports to have the authority to hire and fire and do the yearly annual reviews?
Right. So there are two different components to being a manager. One component you just described, I have the authority to hire, fire, and provide employment-related benefits, leave, approve their leave or approve their bonus, do their appraisals. So that's one part. That's obviously a managerial part. But what if I don't do any of that, but I do supervise? So this is not a sharp, bright line rule. This is a grade that goes from dark gray black to light white to white. So it's difficult to say what works and what doesn't work. But the more in charge of an employee you are, including the authority to hire and fire, the more likely you are to be considered a managerial level employee.
Okay. And does H1B or like L1A, considering both the visas, currently I'm on H1B with I-140 approved. So does that constitute a problem
No.
for like in case if I qualify for EB1C?
No. We've done EB1Cs even for people who were here on H1B because they qualified. Just because they are currently on H1B has no bearing on an EB1C filing. If they are going to be in future filing an EB1C, that's even less relevant. So I'm not concerned about the current H1B. Okay.
So like just to follow up on that, if in my case the person reports from India and he reports the work to me, as a lead I take care of it, but in the system I don't have the authority to hire and fire or like give the annual review. It's a part of the team.
You are more likely to be considered a senior level technical person, not a manager or an executive. One of the indicators is that a manager or an executive doesn't do the work, or at least not primarily. There may be some incidental work required, but they don't do the work. They manage the people or the effort. So they don't do the work themselves.
Okay.
But if you are doing the work yourself, then chances are that you will not be considered an executive or managerial level employee.
Okay. Got it. And finally, one more question. I am currently, as I said, on H1B visa, and my 3-year period is ending in July, and my company already applied and I got approved for 3-year from July 2020 until 2023.
Right.
And now that my company is planning to send me to Canada in a couple of months, So I'm planning to get the stamping done in Canada because I've already done in Canada previously. So is there any rule that I need to get the stamping done only after the start date or like any 90 days before only, before the expiry of the current I-797?
I think it's 4 months before your visa expires. So if your visa is still good for 5 months, they probably will not, I think they have the authority to do so, but they probably will not give you a new visa if you have 4 months or more remaining on your visa stamp. That's my guess. I don't remember the exact rule. Okay. I got to take my next call. Good luck to you, sir.
All right. Thank you.
Bye. Okay. So let's go with area code 980. Or did I get that wrong? Yeah, it's area code 980.
I was done. 980.
Oh, I think I not disconnected, but I ignored. I'm sorry, I put your hand down. Can you put your hand up again? Can you press *5? You have a question? Press *5. Thank you. All right, let's get to you. So this one is area code 646. Yeah, 646. Go ahead, please.
Yeah, hi. This is Nirmal here. Thank you, Rajiv, for answering my question. So you said that I'm okay with my question.
Right. You were talking about. Hang on. You were talking about how is the time counted? So let's say I'm in USA for 3 years, and working for the same group of companies through which I want to go for an L1A. Am I out of luck? And the answer is no, because you're working for the same group of companies. Your 3 years will begin from the date you first entered the United States. So you still have 3 more years or even more, because if you keep working on H-1B for the same group of companies, you will never run out of time.
Okay, I'm on L1A, so it will not never run out of time,
L1A,
right? I don't apply anytime.
Yeah, I don't think that's a problem at all. The same principle should apply. I would have it double checked, because sometimes these things can surprise you, because you never know. There are so many interpretations and so many exceptions. It is always best to check, but to the best of my knowledge, I don't see any issue at all. Okay?
Okay. Thank you very much.
Oh, you're welcome. Good luck. Okay, so let's go on to the next frequently asked question. Boy, we are slow today. Okay, so can I transfer my H-1B? This is from Enshush 2009. Can I transfer my H-1B while my extension is still pending? And the answer is yes, but because your I-94 has expired, you may have to go outside USA for get visa stamping before you can start working the transfer job. Okay. And it should not impact your current case. Your questions were, can H-1B transfer happen in such a case? The answer is yes. Your extension is pending, I-94 is expired, you can apply for a transfer. But unless the extension has been approved by the time your transfer is decided, they're not going to give you status normally within the United States. They're going to say, go outside and get your visa stamping. Will it impact my status in the United States? No, it will not. Can I work for company B still? Company B, which is the transferring company? The answer is not, unless let me rephrase that. So you have your extension pending. Your I-94 has expired. Company B filed your transfer. You can go join them. But if the case is denied, you would have to go outside for visa stamping. When I say case is denied, I'm assuming that the H-1B is approved, but the transfer is denied because you are out of status and the old extension case has been denied. You would have to go outside USA for visa stamping. Okay? So the answer is you can do it, but you may have to go outside. Press *5 if you have a follow-up question on this. No new questions. *5 for a follow-up question. Next question is from Sri168, and this is a very common question. What can I do after my H-1B is denied? Or L1. Many of these applications have the same repercussions. So I'm not going to look at your background details. I'll just try to cover them generically as I go along. First of all, how long can I stay? So that depends. If you are covered by the 60-day grace period rule, and you should discuss it with your lawyers whether you are or you are not, because there are so many detailed implications there. I can't cover them all. If you are covered by the 60-day rule, then you have 60 days to file a new case or a transfer or a change of status. What are my options from collected information? I'll try to see if I have time to do that. We have option to file H-1B in consular processing, always. Can we file an appeal? Yes, but the appeal neither gives you any right to stay in the United States, nor is it any guarantee of approval. Normal appeals, the rate of success of appeals is about 2 to 3%. In our office, probably it is closer to 90 to 95%, because we hardly ever file appeals unless we are convinced that we have a case. Why? Because appeals take too long. They take 8, 9, 10 months, and there is such a low rate of success, we don't want to waste our money. If the case is strong, I might just take it to court. If the case is weak, I might just refile the H-1B premium processing with better supporting documentation, etc. Can we apply any number of applications? And the answer is generically, yes. If you are not subject to the quota, you can have 1,000 H-1B applications going at the same time. Can we apply both appeal and H-1B petition? You can, but at some point, if it is for the same job, with the same employer, the same location, government will make you choose one or the other. They'll say you have an appeal pending for the same job, and you are applying for a new H-1B for the same job. Choose one or the other. Can we withdraw the appeal if we have to do that? Yes, we actually end up doing that. So there are cases where we will file an appeal, still time remaining on the original H-1B. We feel the government is completely off base, but this is not a case we want to take to trial or to court. We'll just file the appeal, and normally it's not a problem because it's not the same case. But if we end up filing another H-1B for the same job, then at some point we will withdraw the appeal. Okay. Let me take a quick look at your facts. I got my H-1B denial February 20th. H-1B expired January 31st. I-94 February 10th. So they give you an extra 10 days. H-1B extension denial date February 20. You already did that. File date, H-1B RFE date, none of that is relevant. So the fact is that you are accruing unlawful presence beginning February 20th. So if you stay here after 180 days of that, you'll be barred from entering the USA for 3 years. Okay, an appeal does not change that. A lawsuit does not change that. Filing a new H-1B does not change that. So just keep this in mind. In lawsuits, we can ask for tolling or stopping of unlawful presence. It's up to the court to give it or not to give it. But without that, filing an appeal doesn't help running off the unlawful presence. Okay. I would, if I were you, let's see, because your I-94 has expired, I would plan on going outside USA. And they can start another H-1B for you, or another employer can start. I'm assuming that you're not subject to the quota. Star 5, if you have a follow-up question on this, star 5. Okay, this question comes from Pennsylvania. Okay, Pennsylvania, I can hear you. Go ahead.
Hi, this is Sid. I'm actually in California.
Okay, but your phone is in Pennsylvania.
I went to Penn State.
Congratulations, good school.
Thank you. So my question is similar to Sri, but my I-94 is expiring on May of 2020.
You have more options.
I-94 is expiring.
You have more options because it's not already expired. If you wanted to buy some time, you could definitely apply for a tourist status while you look for another job or do whatever you need to do. I have a couple of I think I have a blog entry on this. We certainly have at least 5 or 6 frequently asked questions already saved on this on immigration.com. Frequently asked questions. What I did was I told you guys that you can file for a tourist extension or tourist status, and because you filed it before your current status expired, you are okay to stay while that is pending. By the time they decide that, it will be already 6-7 months. So just make sure that you are not overstaying your asked for time. So if you ask for 6 months, file another extension if you still need more time within those 6 months. Otherwise, you'll have to go outside US and come back. So keep that in mind, but you have the option of extending your stay, but not your right to work. And chances are, if your old status has expired and you have your tourist status request pending, you cannot start working just upon filing of the H-1B, and you will have to go outside USA for visa stamping when the H-1B is approved. Okay.
Got it. Thank you. I'm scheduling a call with you on Monday also. I'll talk to you more on this. Thank you for replying. Thank you.
But one second, are you still in school or are you out of school now? Oh, you are out of school, right?
Yeah, I mean, I'm in,
Okay.
I'm out of school. I've worked for 14 plus years.
Okay. Now, because if you're a student, I would have just taken your call now. You can afford to pay our fees. That's fine. We'll talk on Monday. Okay.
Just based on the phone number, you can give me a discount.
No. I don't give discounts and I don't take discounts. So when you come and you write software for me, I will expect to pay your full fees. Okay.
Absolutely, sir. You're absolutely stellar advice. Thank you.
You're welcome. Good luck. Yeah, many years ago, I had a very good client who said, well, we'll give you, they were a big music house and I'm very fond of music. So he said, we'll give you big discount on music collection. I said, no, I'll pay your full price, because if you give me a discount, maybe I'll save a couple $100. But if I give you a discount, it'll be a couple of $1,000. So no, let's keep it professional. So we have one more question. Area code, this is from California. Okay. California, go ahead, please. California.
Hi, Rajiv. Hi. My question is related to the same follow-up question on that if I-94 is expired and one has to go outside US to stamp and come, how long the stamping will take? Is it a chance that it will get into administrative processing?
These days what they are doing is they are trying to delay as many cases as they can. One of my colleagues from my own office, one of our H-1B workers, team members, clear-cut case. There's nothing complicated about it. They held her up for 5 weeks for big in quote administrative processing end quote. I have another case we were discussing this morning, I think. Yeah, at 10 o'clock. No, maybe yesterday at 10 o'clock. We were discussing multinational company, well-established company, very clear-cut case, and they've got the guy sitting there now for a couple of weeks. So under the best of circumstances, you can expect a few weeks delay. Some people are getting their H1s done right away, but more common is a few weeks delay and also sometimes a few months delay. Okay.
So is it advisable to go to Canada and come back because it is also considered out of US?
That's what I had told my colleague who went to India. And you know how it is in Hindi, they say Chirag Tale Andhera. They would not listen to my advice because they don't pay for it. So she still decided, no, I'm going to go to India and apply. And she didn't go to Canada. Everybody I've sent to Canada, Mexico, Jamaica, or Bahamas, they seem to have had no problems getting their H-1B stamping. But in India, it seems that they distrust Indians more than they distrust anywhere else. Or maybe that's just their normal working methodology. So yes, third countries could be better, but be careful. If your visa is held up there or denied, then you will not be able to fly into the United States. You would have to return to your home country and apply again.
Okay. And one last thing, that will this all impact your I-140 going
Not at
forward?
all.
Like if you have
Not
an
at all.
approved
Not at all.
I-140?
Not at all.
Not at
The
all.
only way your I-140 could
Okay.
get impacted is, for example, if you have a fake degree. Now, I've never had those cases, but I can theoretically think of a possibility where somebody said, oh, I went to, I don't know, the National School of Scholars, and there's no such school. So something like that, where there's fraud or something about your degrees, that could affect your green card. Otherwise, the fact that the H-1B is in trouble does not have or should not have any impact directly on the I-140. Okay?
Okay. Thank you so
You're
much.
welcome. Good luck, ma'am.
Thank you.
Okay, so next frequently asked question. This one I can write a book on. And in fact, I wrote, I think, a 20-30 page article on this. It's on our website. If you go to information about Rajiv, and it has a bunch of things, and one of them is articles that I've written. I've written an article called Liquidated Damages for H-1B Employee Contracts. So the idea is that because H-1B employees are so heavily regulated, or I should rephrase that, H-1B employers are so heavily regulated, anything they do can be questioned by the Department of Labor. So Subhash is getting an offer where they want him to work for 5 years. Please check on the state laws about whether these contracts are even legal or enforceable. Normally, and I don't know the law of Nebraska, I'm not admitted to Nebraska, I can't comment about the laws of Nebraska, but I can tell you generically, under the US constitutional laws, agreements in restraint of trade are frowned upon. It was the same in India. I think it is the same in UK and Canada. Any agreements that tend to curtail or contain somebody's right to work are frowned upon, and the courts construe them strictly. Under US immigration laws, you cannot attach a penalty to somebody leaving you early. So if you say, well, if you leave me before 5 years, I will charge you the attorney's fees that I have given. That's illegal. They can't charge that back. Or it says you have to give me $500,000. That's a penalty clearly. That's not a recoupment of any damage I might cause you. So if it is a recoupment of illegal or payments that would be illegal to recoup, or if it is an exaggerated amount that could amount to a penalty, it most certainly is not allowed, and that contract is not worth the paper it's written on. Okay? So the statement is offering this position, company agrees they will sponsor you. Both parties understand you'll be employed for a minimum of 5 years. You see, here is what I think. Okay? Now, this is really a matter of state law, but let's say if this case was in Virginia, I don't know how Nebraska deals with it. If this case was in Virginia or DC where I'm admitted, my first question would be, if I don't follow this clause, what can you do? Okay. Typically, the employer can sue me for actual damages. For example, if they lost a big contract because I left, they could ask for consequential damages, loss of goodwill, things like that. But they really cannot do anything beyond that. They can't make you work for 5 years. They can sue you for damages. Will they win? That depends upon the state law and the circumstances of the case. *5 if you have a follow-up question. *5. Okay. And this is I think this is the last. Oh, there is a follow-up question. Okay. Let's go back to Subhash. And this call is from Wisconsin. Wisconsin, go ahead, please.
Hi, sir. This is Subhash.
Yes, sir.
So my question is,
Sir, you faded out there. I don't know what you said. Can you repeat it, please? Get close to the phone and repeat it.
In the employment letter, it says both the parties agree for 5 years employment, and Nebraska state is at will state.
Yeah.
So is it okay?
No, this is not something I can advise you on, because it's a mixture of immigration law and of state law. From an immigration perspective,
Okay.
this contract has no meaning because nobody can bind you. You need to discuss with a lawyer locally what the implication of this particular clause is. Remember, an employer can always sue you for actual damages. If your leaving causes them harm, they can sue you. But these kinds of contracts, I think, are highly suspect. Please talk to a Nebraska lawyer. Okay?
Okay. And the other question is, if I get employment within this timeline, like probably in 1 month, can I file H-1B and join other companies?
Okay, leaving aside any contractual obligations and talking only about immigration law, there's no requirement that you be bound to a company that processed your H-1B even for 1 day. So you could potentially change your employer 1 month after getting the H-1B approval, 1 day after getting the H-1B approval, no problem at all.
No, I'm saying once I register and so in the month of April, can I go to other company and
Okay.
work for them?
Okay. Are you saying that you filed a quota case? Can I leave before the
Yep.
approval? Is that what you're saying?
Right.
And the answer is,
Yep.
is almost certainly not. Because until your case is approved, you're still subject to the quota. If you leave, they're not going to proceed forward with your case.
Okay.
Okay?
Okay. Thank you. Thank you.
Good luck, sir. Okay. So let's see. And I think this is the last frequently asked question. And this is also a problem we've encountered very frequently. Many times, especially from India, I have not had that problem with other countries, but mostly from India, what will happen is that you have a provisional diploma. You don't have the final degree. They'll give you a provisional diploma. So what do you do in those cases? So Manny says, I'm currently working on H-4EAD. Employer wants to file H-1B. Attorney needs my degree evaluation. I've got a BSc in IT mark sheet, degree certificate, convocation, and post-graduation mark sheet, degree certificate, but missing the convocation for my master's. Is there a solution? So there is actually a few decided cases on this, and I don't remember the language of them off the top of my head. We've dealt with this issue successfully many, many times. It's not been a problem. I'm going to give you a guess from my memory. Okay. So my guess is when you have finished your degree, but you don't have the degree certificate, only a provisional or a mark statement, what they call transcripts in this country, you can get a letter from the school saying that all requirements, and you can write this down, all requirements for completion of the award of your degree were fulfilled, and that the only thing that was missing was the actual award, which is given at a convocation period. As far as the school is concerned, you are considered to have fully graduated after completing your degree. So something like that from the school could help. The exact words you can get off of the case. There were a couple of cases decided by the Administrative Appeals Office. So it's not an insurmountable issue. *5 if you have a follow-up question. *5. Okay, no, but in any case, I also want you to know, they don't have to evaluate all this right now. You have time. Right now, they can just put you through, assuming that you will get an evaluation that's equivalent to at least a US bachelor's. So they shouldn't be holding up your filing for the electronic H-1B registration, okay? All right, so this is done. Now let's go back to any follow-up questions on what I just discussed? *5. Okay, so now let's go back to non-frequently asked questions. And let's go through them. So this is, I got I-130 filed for my husband. It was approved. I'm a green card holder, USA. Beneficiary husband is a permanent resident of Canada, but citizen of India. Oh, of course. He has a right to get his case processed through Canada. No problem at all. Yeah. So you should contact the NVC and see what you need to do. And yes, you should mention that in the NVC application. Okay. Yeah, no problem at all. Going from Canada is fine, even as a permanent resident. Now there's a hand up from somebody, and I'm not sure, this is from Illinois, in relation to some question. Go ahead, Illinois, what is your question?
Hi, sir. It is related to the same question that you are looking at right now.
Yes,
so, originally on the I-130 application,
no, don't worry about that.
we incorrectly stated New Delhi.
Don't worry about
New
that.
Delhi as the consulate.
Don't worry about that. That can be corrected. Not a big problem.
Okay.
Relatively minor
Okay.
issue.
Okay.
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 Good luck.
Okay. Thank you very much.
You're welcome. Bye-bye. Okay, so then we come to F1 to H4 conversion. This is from Gabriela. I have been on F1 on a PhD program and now on OPT since August 2019. Not yet graduated, but I have a job part-time as a lecturer in the university. Husband has an H1B, I-140 is approved. H1B will be renewed in September of this year. I've applied for my H4 and H4 EAD. It's not approved yet. By the time the EAD is approved, my husband will need to file his extension. Can I make a second application? Yes, you can. Does the second application get processed with the first one? This is one of those areas of procedure nobody knows what they're going to do. But you should file both an extension and an EAD and mention why you are doing it twice, letting them know that the old one is still pending. Okay. Second, can I make a second? The answer is yes. I work in State University as a part-time lecturer. I doubt if it could convert to a full-time. Any possibility of a green card approval by EB1A, EB1B, EB2 NIW? And the answer is, well, first of all, for EB2 NIW, you don't need a job. But you need some interest in what you do. So, for example, if you were a researcher, there have been some approaches made either by the industry or the academia to either hire you or work with you on your projects. That would be sort of the thing that would get you a national interest waiver. For outstanding researcher, EB1B, professor category, you need a faculty or a permanent job, or a non-temporary job, I should say. So tenure track, or non-temporary. That is a term of art. There are many implications to that, but that's what you need. And EB1A doesn't require a job at all. That's totally based upon your resume. Okay. *5, Gabriela, if you have a question. *5. Okay. Exec transfer says, I'm considering a change of job using job portability, new location in a different state, and there's an AOS pending for me and my dependents. If this were to happen, I may be in temporary extended stay hotel for a few months. Should I file an AR11? Oh, absolutely. Absolutely. You file an AR11 every time you move. I don't care even if you're going to be there for 3 weeks. So that is a good idea to do. If I change only my address, look, you should change everybody's address. AR11 is non-discretionary. You have to file it. It's mandatory. *5, if you have a follow-up question, *5. Okay. Going on to the next question. Asylum, I'm sorry, I don't do political asylums. No idea. My apologies. Lucky CK1. Wife sponsored me for F2A visa, California. I-30 has been moved to Nebraska. Why has the case been moved? Typically, they do workload redistribution. That's a very common reason for moving it. I can see that California is already processing April 2019. Nebraska is processing December 2017. When will my case be approved? I think it will come under the Nebraska workload. So that would be my guess. Can I apply for MS at US University? when you have a green card pending, chances of getting a student visa are slim, but not impossible. When I came to the United States in 1987, my green card was pending, but my student visa was approved. The consular officer was convinced that I will not go into USA or remain illegally. Okay, so that's what you have to shoot for. *5 if you have a follow-up question. *5. So you could apply for a student visa. It's very unlikely that you will get it. No harm trying. So this question is coming from India, I guess. Give me 1 second. Let me double check. Looks like it's from an unknown number, but it looks like India. Go ahead. Go ahead with your question, please.
Yeah, thank you, Rajiv, for the information. The follow-up question is, as my wife is in US, can she sponsor my US program, whatever I'm planning for the US program?
Can she sponsor, you mean for your I-20 for your student visa admission? Yes, of course. No
Yes.
problem. Okay.
Okay, because the student visa interview time, it should not be a problem.
No, well, so
Thank
you
you
see,
for the
remember,
information. Thank you.
in the student visa form that you fill out, what is it called, DS-260, you have to disclose that your wife is living in US. You cannot. If you try to conceal that fact, it will be a permanent bar from entering. So if you reveal that, in any case, it doesn't matter whether she has sponsored you or not. Okay?
Okay.
Good luck.
Thank you.
Good luck. Good luck, sir.
Thank you.
All right. Bye-bye. Okay, I think, this is the last question. I won't have time for any new questions, but this is the last question. May 2019, my company filed an H-1B application extension and amendment with a request for extension up to April 2020. That's your 6-year max cutout date. You received an RFE. Now you received I-140 approval. Can I file another petition? Absolutely. Please file another H-1B extension right away. And that is really the best thing to do. Don't wait for the decision. Do respond to the RFE, but you can file an H-1B extension even today. If you have your LCA ready, go ahead and file it. No problem at all. We do it all the time. *5 if you have a follow-up question on this. *5, okay. This one is coming to us also from New York, I think. Yeah, New York. Yeah, New York, go ahead, please.
Yeah, good afternoon, sir. I'm Srinivas. So my question is like, there is no change to the project or location or role. So still can we file a new H-1B application?
Absolutely.
Based on the I-140 approval?
Absolutely. What you're asking for is
Okay.
extra time, not a different job. So perfectly fine.
Correct, yeah.
Perfectly fine.
Okay, so my attorney somehow thinks that I should first respond to RFP first and then wait for that and then file a new application.
Not at all. Not at all. Because
okay.
No, not at all. Because even if your case were approved, it would only be approved in April, which is just next month. You need to file a bridge petition immediately.
Okay. And can I wait again? Does that start my 240-day period till I get the decision to file in regular mode?
See, the 240-day period begins from the date your current status expires. So that would begin in April, okay? And the 240 days are applicable only where an application is filed for an extension without change. So if you file an amendment or an extension with change, you don't have 240 days, you have unlimited time.
Sorry, so I can file it and I have time until the decision comes because
Yes.
my actual I-94 expired on December 2019.
Yeah,
December 8th,
I
2019.
think you should be okay because you have a case, an extension filed before your current I-94 expired. So it's a little complicated. I don't have the time to explain the entire nuances, but I'll tell you the to-do items. File for your H-1B extension as quickly as you can. There's no harm in doing that.
Okay.
And you can file it non-premium for now. As and when your April case gets approved, premium the pending case. Okay?
Okay.
Good luck. Good luck, sir.
Yeah. Thank you so much.
Always a pleasure. Folks, I always enjoy talking with all of you. Thank you so much for attending, and I'll see you again in 2 weeks. Be well, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.